sexually violent predator law applies to a very narrow group of sex offenders.
Not only do they have to have certain qualifying prior convictions, they also have to have been found by mental health experts to suffer from a diagnosed mental condition that actually predisposes them to commit future sexually violent offenses. And that they're unable to control that behavior.
Many sex offenders who committed their crimes prior to 1984 faced a maximum term of 8 years in prison, but by using the SVP law, the DA's office has succeeded in getting civil commitments for many offenders who otherwise would have been released from prison.
So because of the existence of this SVP law, we've been able to keep them in a state hospital where they receive treatment. Now, we all understand that for many of these offenders, there's no cure. But the goal of treatment is to reduce the risk of reoffense. If we block release outright, then the courts may very well find the SVP law is unconstitutional, and we'll take that tool out of our toolbox.
A sexually violent predator committed to the hospital for treatment may petition the court to review their case after 1 year, but the outcome depends on the opinions of medical experts.
Well, they can determine that the person is not safe enough to be released and deny the petition for conditional release. The court can determine they are safe enough to be released under these strict terms and conditions. And there's also the potential that the court can find the person no longer meets the criteria of the SVP law and actually release the person outright.
These are the sexually violent predators that, as of this month, have been released into our community for supervised outpatient treatment. You can view their profiles and learn more about the SVP law on our website.
Steps are being taken to ensure that they are not released unless they absolutely have proved that they are ready for the next level. And that decision is one that is made by the courts. And our job as the DA is to make sure that all the information we can put out there in front of the judge is made available so that the court is in the best position possible to know whether this person truly is ready for conditional release.